Well, thank you very much to all the speakers, and thank you very much for to Marina Cassini, for this wonderful leading of the conversation of the panel. We have already covered a lot of topics, probably well beyond our expectations, but now we are going to focus on another aspect of the abortion. We are going to focus on the legal aspects. So we are going to discuss up to what point the abortion, the idea of integrating the abortion in the European Charter of Fundamental Rights is consistent with the legal framework that we have created in Europe during the last years. No? So in order to do that, we have another group of experts, which is also a very interesting group of experts. So I'm calling to the stage Íñigo Méndez de Vigo, who is going to be our leader now. Thank you very much. Íñigo Méndez de Vigo was vice chairman of the EU Commission on a Charter of Fundamental Rights, so he knows perfectly well the topic that we are going to be talking about now. Then we have Paulo Rangel. Thank you very much, Paulo. Paulo is the vice president of the European Popular Party. So thank you very much for coming. Gregor Papping, who is the president of the European Center for Law and Justice, who is also making a wonderful job on tracking all the the hidden tricks, no, that sometimes we can find in the international organizations, and how apparently they are working to promote our well-being, and at the end they are working probably against us, no, more than for us. Finally, we have Tonio Borg. Thank you very much. Tonio Borg is a professor of public law at the Malta University and former EU commissioner. So thank you very much, Tonio Borg. And finally, we have Natalia Choa, who is a colleague because she's also a public international law professor in the Camilo José Cela University in Spain. So welcome. International law, yeah, like me. Yeah. So thank you very much. I leave the floor to Íñigo. Thank you very much.
Thank you, Álvaro, and thank you. Does it work? Yes. Thank you to Jaime Mayor and to Alfonso Bullón de Mendoza for the organization of this meeting. I think the first panels have been really interesting. I hope this one will follow. Je crois que la seule prérogative d'un président est d'échanger l'ordre des intervenants. Et donc, je vais le faire. Je vais le faire.
I believe that I'm allowed to change the order of speakers due to my authority, and I'd like to give the floor to Gregor Puping. He made a comparative study on the European Convention on Human Rights and has worked largely in the field of international law, especially in the United States, and he will answer to the question, is abortion a fundamental right? So when I studied religion in the school many years ago, I remember that there was this question, are you Christian? And my answer was, yes, I'm Christian by the grace of God. I'd like to know if abortion is a right.
Chrétien, mais je suis aussi français. Et donc, comment? Et donc, j'ai du mal à répondre de façon tranchée aux questions. Alors, c'est ça, bien sûr. Alors, oui, mais donc.
Well, it's difficult for me to answer certain questions in a solid way. It's a pleasure for me to be here with you. Thanks for the question. What I need to say today about this topic is very simple and can be summarized into sentences. First of all, yes, we can prove from the legal point of view that abortion is not a right, and we can also say that it's not a freedom. And this is a true demonstration But in order to prove this, we need to take a look at a conception of human rights that, in my opinion, is authentic from the historical and philosophical point of view. So, yes, from the law, we can prove that there is no fundamental right to abortion, and furthermore, both in the Strasbourg court as in the European Court of Human Rights, they say it clearly. There is not a right to abortion based on human rights because there exists something, there is something different than the mother. The European Court has said that abortion not only questions the private life of the mother, there is something else. The way in which we name this thing varies from one country to the other. And there is a concept that exceeds the framework of private life. Also, the Supreme Court of the United States said is that there is something else different to the human rights, and it says that we cannot have a right to that other thing. So according to the European right, it is a third party, because we always consider this according to the second article of the charter, and therefore it can be proved. And we can also prove that regarding the rights of the United Nations sees the right to legalize abortion. There is no convention of this type, and we can prove it. Nevertheless, human rights are very fragile. Human rights are very rooted in some anthropological conception of men. And these are a legal language, but also a very political language, a language that has a moral nature. It is a language that is different from the common law. We should not mistake this, because it says that human rights are something very strict, something that is within a progressive conception of society, and therefore, in the normal law, the principle of non-contradiction is applied. We need to make reference to certain rules, and the principle of non-contradiction takes us to solve, so allows us to solve our problem. Human rights have a progressive vision, and we cannot go back to the past. We cannot see the will of the writers of this charter against the future. A past can never be an argument against the future. Even the present cannot be an argument against the future. Therefore, the domain of human rights for us, when we have a political fight, one needs to choose the field. So the promoters of abortion chose the fields of human rights, not by coincidence. This is a right which is favorable for them, because it only recognizes the individual will in a very abstract context. It is a field of the affirmation of individual rights, and therefore is favorable to these demands of individual rights. It's a very abstract field because it doesn't call on the reality. It's not necessary to speak about the causes of abortion, but we need to speak about the consequences of the abortion and of the child. And we only speak about the abstract right to abortion. And since the human rights have a progressive, dynamic approach and very individualistic, therefore the right to abortion falls within this view, and it's very difficult to oppose it. The second element, of course, in Brussels, we have the danger of including the right to abortion in the Charter of Fundamental Rights. This is a debate that is going on these past weeks in the European context, and this debate that is being done in Brussels will have an effect. It shows that a majority of the European Court is in favor of including this right in the Charter. this consensus has national consequences, but also in the other international and European institutions, the European the European Charter to Human Rights. For example, this court needs to pronounce itself against Poland, and the chances are that this summer the European Court of Human Rights condemns Poland due to their legislation in regarding the abortion after the judgment of the Constitutional Court, and this could happen in the next months. Therefore, if we find this danger in Brussels, the danger is even higher in Strasbourg. And Strasbourg listens to Brussels, and if they see that the European Parliament says that abortion is a European right, the trend will be to apply it, and therefore the danger is even greater in Strasbourg than in Brussels, and therefore we need to work with these institutions devoted to human rights. This is the main message. So the field of human rights is favorable to the promoters of abortion. It is a strategic approach, and the chances are that the sentence is against Poland. What consequences do we find in this? Well, we need to choose the field from which we want to fight. We need to choose our field, and the one that is more positive for us, and the one that will, it doesn't need to be evil, so to say. It needs to be something natural, and the most natural thing is reality. If we defend the truth, the field that will defend our view will be the reality. What does this mean? It will mean to put the question of abortion again in the human and social point of view. Our enemies want to have an ideological debate, but we need to get out this context, this debate, and see it again from the perspective of the human and social reality, which is the causes of abortion, the consequences of abortion for women, for couples. If we see this human and social reality, we will not be able, so we will need to adopt a constructive approach, and we will be able to prove that abortion is not a freedom legally, and it's even easier to prove it from the human point of view. We just need to see the statistics. 2/3 of women who have an abortion in Switzerland do not have an academic history further from secondary school. So 30% of the most poor women of France have a higher risk of abortion than the richer ones. So these are women who are alone, and these have a 37% more chances to have an abortion than the others. So there is a social determinism applied to abortion, and this determinism proves that abortion is not a freedom. Therefore, when we want to put us in the ideological field, and a field that is not ours, we need to get out of that ideological debate and recover again the charity and the human point of view. Thank you very much.
Merci, Gregor. Je pense que les applaudissements montrent le soutien.
Thank you, Gregor. I think that the
I turn myself to Tonio Borg.
also proof
he's also
the
an
support
academic
to your
scholar,
ideas.
but he's been in politics. And those who have been in politics are always in politics. Even if we are not active, we think politically. Like the Pope. Well, I wouldn't mention the Pope. I hesitate. But anyway, Tonio has been a commissioner, member of the European Commission. So in this debate, it has been mentioned before that during the French presidency, there was this initiative to say we should rule on abortion at European level. We know about the necessity of the Commission to apply a legal base when it makes a proposal. So what you think from, I would say, from the point of view of regulation and from your experience in the Commission, how would it be possible that the Commission puts forward any proposal, any legislative proposal on this issue? Thank you, Tonio.
Thank you. First of all, I take pride of the fact that I come from a country, the only country in the European Union, which does not allow abortion, except, of course, when there is a direct, actual threat to the life of the mother. You asked me about how the Commission works from the inside, which is important because I only understood how the EU works when I was Commissioner, because you can see how it works from inside. And contrary to what the British press say, the laws do not fall from heaven in Brussels. There is a very laborious, long process, including within the Commission. So the first thing they ask you when you propose something, do you have the money for it? Secondly, does it go against the principle of subsidiarity? Subsidiarity, a very important principle, which goes back to the Christian democratic ideology, subsidiarity. Today, everybody speaks of subsidiarity, not only on abortion, on all matters, but we should also mention subsidiarity in the context of abortion. So they ask you, is this something which you are proposing within the competence of the Commission? And the treaties are clear. Let me give you my personal experience. As you know, when I was proposed as Commissioner to fill in the last 2 years of the previous Commissioner who had resigned, there were some who tried to stage a sort of Buttiglione #2. And I had to study in 3 weeks the acquis on health, including very minute details. And I think that during the hearing, I showed that I knew something about the acquis, and I was prepared to apply the acquis. But most of the questions, particularly from the left, were, but you are against abortion. So what? Is this something which the Commissioner can decide? No, neither in favor nor against. And I remember I told the Portuguese socialist MEP, I did not draft the treaties, you drafted the treaties. And according to the treaties, abortion, euthanasia, even divorce, is something which till now is in the exclusive hands of the member states. So when you are objecting to my nomination because I am against abortion, you are in actual fact telling me, because of your beliefs, we will not, your religious beliefs, or even non-religious beliefs, you don't need to be a Catholic or a Christian to be against abortion. Abortion is wrong, not because it is condemned by the Catholic Church, but the Catholic Church condemns abortion because abortion is wrong. But this means that if I'm a practicing Catholic, I can never be a European Commissioner. Which reminds me of the famous Houston speech, which John F. Kennedy had delivered in 1960, when they tried to block his nomination as President of the United States because he was a Catholic. And we would like to quote from the speech because it is extremely important. Are we going to exclude people just because they are Catholics or because they are Christians? And he said as follows in 1960. If this election, he's referring to the presidential election of 1960, is decided on the basis that 40 million Americans lost their chance of being president on the day they were baptized as Catholics, then it is the whole nation that will be the loser in the eyes of Catholics and non-Catholics around the world, in the eyes of history and in the eyes of our own people. For while this year it may be a Catholic against whom the finger of suspicion is pointed, in other years it has been and may someday be again a Jew or a Quaker or a Unitarian or a Baptist, and may I add, or a Muslim. So we can never have a Muslim commissioner in the future just because of his belief. Now, on this question of, I'm also a law professor, so yes. So there is a difference between an ordinary right and a fundamental human right. When we say something is fundamental, it means it is superior to the ordinary rights. So you cannot go against a fundamental human right. Now, no international human rights treaty has ever recognized a fundamental right to abortion. On the contrary, the Article 4 of the American Convention on Human Rights, which applies mostly in Latin America, says that the right to life, as a rule, should be recognized from the moment of conception. So not only is there no international human rights treaty, but there is one which states exactly to the contrary of what is being proposed. And as Gregor said, till now at least, the European Court of Human Rights has not recognized abortion as a fundamental human right, nor, to be fair, has it stated that abortion goes against the right to life. It has left this margin of appreciation. Each member state of the Council of Europe decides whether to allow abortion or not, which makes me smile or sometimes cry when I read the contents of the July 7th resolution of the European Parliament, which criticized the reversal of Roe versus Wade, which means when Roe versus Wade was reversed, it means that now each abortion is still allowed in the United States, but each state decides whether to allow abortion or not. So what the European Parliament did last July was criticizing what is the situation in Europe. So we actually, by a 2/3 majority, and I must say, with the support even of some members of the European People's Party, which for me is very offensive, but anyhow. And we are criticizing a legal situation in a foreign country, which is again very strange. Now we are trying to be arbiters of the entire world, even of parts of the free world, criticizing the United States for being like us, Secondly, from a legal point of view, it is absolutely clear that to change the treaties and to put abortion as a fundamental human right, you need to change by unanimity the treaties and the charter. And the charter is part of the treaties. And you can only change unanimity by unanimity, which is why the citizens' initiative in favor of abortion being treated as a fundamental human right, till now, has been rejected by the Commission on this ground, that it is not within the competence of the Commission to propose something which is in the exclusive hands of the member states. I forgot to mention one other thing. In 1986, there was a case against Ireland before the European Court, not on abortion, on divorce. Whether, now divorce exists in all member states of the Council of Europe and of the European Union. And yet, the European Court of Human Rights said there is no fundamental right to divorce, that is to say the right to marry, does not include the fundamental right to marry a second time. Now, if this is true for divorce, we lawyers say multo magis, even more so, should it apply as regards the termination of a pregnancy. Because if there is no fundamental right to divorce according to the European Court, even more so, there is no fundamental human right to abortion. One last thing, if I may be permitted. There are historical objections as well, not only legal ones, historical ones. If you look at the founder fathers of the European Union, at that time it wasn't called the European Union, but the founder fathers. Adenauer was a member of the Catholic Zentrum Party. It was called before the war the Catholic Party. De Gasperi is considered by the Catholic Church to be a servant of God, which is the first step towards canonization. Schumann is recognized by the Catholic Church as a venerabile. I mean, can anyone in his right senses, from the historical point of view, say that the founding fathers envisaged not only a right to abortion, but that this right be imposed on each and every member states, whether they like it or not. So it goes against, so I remember President Barroso, under whom I served, used to describe the EU as a federation of sovereign states, which it's like a contradiction in terms, because if it's a federation, then you are not. No, but it's true, it's a federation, but of sovereign states. The founding fathers never intended that the union would absorb all the rights of the member states. There are certain matters where the Commission has exclusive competence, like competition. There are other things where it is co-legislator between the Parliament and the Council, and there are other reserved matters, including abortion, which is exclusively in the hands of the member states, which is why I agree with Gregor that the danger as regards this topic, and I really conclude now, does not come from Brussels, because here the treaties are clear and they need a unanimity to change. The real danger comes from the European Court of Human Rights in Strasbourg, because they have changed attitudes on a number of occasions, and they could change the attitude as well on abortion. And that would therefore put even more pressure on Brussels, because Brussels affects Strasbourg and Strasbourg affects Brussels as well. Thank you.
Thank you very much, Tonio. I was not a member of the European Parliament at the time when you passed the hearings. So I couldn't appreciate if you had really learned well your subject. But I was in government at the time. I was Minister for Europe, and I remember your fighting spirit in the European Parliament, and I'm happy to see that your fighting spirit is there. So thank you so much for this intervention. So I turn into my language, Natalia Ruiz Ochoa Ruiz. El orden de los factores sigue alterado.
I will now change to Spanish. Natalia Ochoa Ruiz, who is a professor at the Camilo José Cela University. And we've heard twice already that the legal base are a precondition of any action by the European Commission, and that if we are to change the European Charter to include abortion, this has to be done by means of the mechanisms foreseen in the treaty. Can you tell us about this topic from your point of view, from the academia? Well, thank you very much indeed for having invited me to this event, being here with distinguished colleagues, and to answer the question set forward by Mr. Chairman. We could discuss a great many things, but let's start by saying that indeed there's no right to abortion per se. There's no international mechanism of international treaties that recognize the right to abortion. We need to be clear on this, because the control or surveillance bodies, not only of the European Court of Human Rights, but also by the United Nations, the Human Rights Committee, the Committee the Elimination Discrimination Against Women, the Committee, the Rights of Children, all of these mechanisms and supervisory bodies that have been coining terms that are not including in treaties. We hear talk about sexual and reproductive rights, a right to abortion, a consolidated right to abortion, legal and safe abortion. These terms that have not been included in international treaties. So I don't know whether there are many legal experts in the room, but those of us who study international law know how this is done. And that happens these days through international treaties. States get together in conferences or in international bodies and following very long discussions, agree on a text to be included in a treaty, which is open to signature, ratification, and adhesion of signatories. So states are the main lawmakers when it comes to international law. And after treaties are adopted, the latter decide whether to ratify them, and it is only mandatory for those signatories. Why am I saying this? Well, because there has not been any agreements, if you see legally binding treaties, and there are no international treaties that include a right to abortion or the sexual and reproductive rights. All of this is part of the so-called agreed language. What is agreed language? Well, in international conferences on population, the rights of women, and so on, that you're perfectly familiar with, and the supervisory bodies of international treaties, the Committee on Human Rights, repeat mantras, and they start to talk about abortion that has to be legal and safe when recognized. They talk about the sexual and reproductive right, sexual and reproductive health, or that women should not die because they undergo clandestine abortion. So this message seeps in, and these days you come across numerous documents adopted by said supervisory bodies that are not legally binding, but that have an impact and put great pressure and are changing language. Mind you, there's a legal subterfuge. We have not managed states to adopt international treaties on human rights. However, we're going to change the sense of the terms of the treaties that have been adopted. How? By agreed language, the ultimate goal of which is to constitute an international custom, which is the second main source of international law. We have international treaties and international customs. What has not been agreed on treaties, by insisting and repeating again and again observations, opinions, and so on, they manage these terms to be understood as they want, and we have to be prudent, cautious. Another significant strategy in order to disseminate these so-called sexual reproductive rights, an important strategy was saying, especially by the European Commission and some states and their foreign policies, is the conditionality of human rights, the cross-compliance of human rights. The EU only signs treaties, trade agreements with other states, and bestows development aid insofar as the counterpart or the beneficiary is committed to including rules, regulations, or policies on human rights, including as they are interpreted by the European Union or the organization that funds this. And this is the way by which those sexual and reproductive rights, population control have been included left and right. I just said that there are no international treaties that recognizes a right to abortion. And I correct myself, which is the Protocol to the African Charter on the Rights of Women, 2003. In this protocol, which includes an article, I have this in my notes, I don't remember the article, but it makes reference to the sexual and reproductive health, and apparently it mentions safe abortion. So this article that I am discussing, which goes against the very way Africans think, was imposed by some lobbies that funded developing countries, and it was an imposition. And this kind of policy has been reported in a great many fora as a new way of cultural colonialism. So Europe would be exporting these new values by development aid or common trade policies, to mention only two. I have referred to the EU bodies and the African Protocol, and also the European Court of Human Rights has undertaken in a very significant task, my colleagues have mentioned this, to reinterpret the articles in the European Convention on Human Rights, especially Article 8, what some authors call the endless article, where everything and anything can be included. Many things that had not been included have been introduced by reinterpreting a respect to private life. And by this means, they've reached abortion, euthanasia, in vitro fertilization, subrogated maternity have reached the European Court of Human Rights, and all of this has distorted the original sense because Article 2 of the Treaty of Rome that my colleagues have mentioned recognizes the right to life and establishes some exceptions, among which, for example, self-defense, when you're depriving somebody of life on the grounds of self-defense. As per Article 2, all the exceptions to fundamental rights need to be understood as weighted exceptions. But with the European Court of Human Rights, that has not been so. The latter has weighted the right to life of the unborn and the right to the respect for private life of pregnant women. They have not recognized the right to abortion and has admitted that the unborn may be protected by Article 2. Notwithstanding this, in the numerous rulings on voluntary abortion, the European Court of Human Rights has defined the level of protection that the unborn deserves. And I think that is a significant loophole on the part of the European Court of Human Rights. There's a recent ruling, I think it was in the fall of 2022, that I think is interesting, one against Russia and the other one against Moldova on forced abortion. And this is interesting because it is the first time that this tribunal faces two charges of forced abortion. There was a 22-year-old woman who had become pregnant, and they misled her to abort in a public state hospital against her will. She said many times that she didn't want to abort. She wanted to have the baby. She did not sign a document saying that she had been informed, and the following numerous instances reached the European Court of Human Rights. And then there was this other ruling on 3 women with some mental disability in Moldova who had been raped, and by the doctor of the institution where they were institutionalized. They became pregnant and were forced to abort without having their informed consent, and they'd gone through the different court instances. In this case, well, in both cases rather, the court concluded that forced abortion equated to mistreatment and found Russia and Moldova guilty. What I think is most interesting of said rulings is that it is the first time that this court rules on forced abortion, which is a reality. And it's clear that in those countries where abortion is legal, exists, or is extended, it happens with very little control. And there are many cases of forced abortion. Sadly, Spanish people know this. You know that there are women who are pregnant to go to hospital, and doctors ask, do you want to have the baby? You have to decide now because the clock is ticking. So what I'm trying to say is that these rulings underline the existence of forced abortion, and this has to do with vulnerability of women, and there are psychological and physical consequences of these abortions in women. Very well then. So if there's no right to abortion that is internationally enshrined, and if there's an attempt to include this by using legal subterfuges like, for example, agreed language and the human rights conditionality across compliance, what should we do at an EU level? Well, the EU is an international organization that is supranational and has attribution powers, meaning that the latter can only act on competences that are devolved by the states and has no power to regulate abortion in any circumstance. Anything that is not foreseen in treaties, inherent or explicitly, cannot be regulated by the EU. So it would clearly be overreaching, and it could be challenged by the court in Luxembourg by the action of annulment. So this does not have enough legal basis. Abortion does not have the legal basis. There's no legal base, not even when it comes to healthcare provisions. They would have to change treaties or the Charter or Fundamental Rights of the EU. And as the chair was saying, we'd have to apply Article 48 of the Treaty of the EU, which foresees the reform of treaties, which is quite long and complex. I will not give you the details. A convention has to be summoned, and the final decision is taken by the party states that have to decide unanimously as per Article 48.4. So there has to be unanimity thus for the EU to have powers when it comes to abortion. We'd have to change or reform treaties, which is not simple. I trust this will not happen. That's what I wanted to say. Thank you. Thank you. That was a lot. Thank you, Professor Ochoa, for your presentation, which is perfectly in line with what our previous speakers said. And I'm glad to hear this, meaning we're going in the right direction. So we have arguments to defend our position. So we've heard here resolutions by the European Parliament, and our final speaker is currently a member of the European Parliament. Some of us have been so, but you are currently a member of the European Parliament. Moreover, since in the 3 previous speeches, which is important, I think, we've discussed what to do now and future risks. Paulo Rangel, who's a member of the European Parliament group, Portugal, has 2 important conclusions. He's a member of the Constitutional Affairs Committee. I was so for 16 years. So when I see one, I put my hand on them to make sure that they're still living and kicking. And secondly, very importantly, Paulo has from the European Parliament has followed up on the so-called Conference on the Future of Europe, as you know, to reform treaties. Well, us at the European Parliament, we invented in '97 this convention. So since we couldn't intervene in the negotiation of fundamental competences, we thought, okay, nothing is said in treaties on whether we can prepare this. And the Commission has gone beyond that and has prepared this before the convention had prepared this on the Conference of the Future of Europe. And Paulo Rangel has been heavily involved in this work and has the view of constitutionalists, which at the end of the day, if the treaties are ever changed, will have to give his opinion. I think that it is great to have you here to hear to what you have to say.
I asked if I should speak in Spanish or in English, and I was advised to speak in English, so I will do it. But I would like to say that I'm really glad to be here today, not only, but also because I can meet so many friends and former colleagues, Elizabeth, Miriam, Alois, Miroslav, and okay, Nuno, that is Portuguese Isilda that I see there, but I would like to say that for me is a special privilege to be here with Jaime Oreja and with Inigo Mendes de Vigo and with Tony Borg. But in these two Spanish colleagues, I have to say that they are still for me a role model of what a parliamentarian should be. And I learned a lot with Inigo and I learned a lot with Jaime. Probably they are not aware of this, but for me, they are still a role model.
Can I tell my family when I go back?
Yes, that was
Called a role model.
yes, that was the only reason why I said this. Then you can tell that at home. Then let me try to answer and to the questions that were made by Inigo. But I have to say that I have a different perspective, not necessarily a different view, probably, I would say, on this issue, because first, there's something that we should be very pragmatic and very realistic. The society has changed. And all the courts, constitutional courts, international courts, they also change their views with the time. We cannot freeze, we cannot stop the wind with our hands. It's impossible. So things are changing. And when you look at the civil society, you see that this is not, I have to say, it's not only the influence of some texts that are approved here and there. This is the mindset of a lot of people. It's not only the influence of, okay, European Parliament approved the resolution and they have these words and they are very bad. Okay, but nobody at home knows that European Parliament approved that. That is an effect also of this change. So what do I think that is very important now is to address the issue that is the main issue of this conference today. Should the abortion become a fundamental right? So I'm not going to discuss, even if I have my opinion, if we should have safe and legal abortion in different member states. That is a matter that we can discuss, but won't change with our will. There's something that we can still avoid, that is to transform the so-called right to abortion in a fundamental right. And that is what is at stake now. We are not discussing if Sweden or Greece or Ireland or Germany are going to reverse their laws on abortion. That is not going to happen. But it is a fundamental step. I'd say that is a drastic change to have abortion as a legal possibility in each legal order, or to have it as a constitutional right. This is totally different. And so what I think that we should do, our effort today, because also as a constitutionalist, because I also teach constitutional law in Catholic University, by the way, in Oporto. Now it's only political science, but it used to be constitutional law. I have to say that for me, I cannot understand that even the ones that are totally in favor of safe and legal abortion, for instance, for 16 weeks, a totally free right, let's call it technically a right, even for them, that they want to transform this in a constitutional right. For me, this is, I cannot believe that someone is defending this. That's why I'm so shocked with the resolutions here in Parliament, that as I know, probably they are not so effective outside the Parliament, but I'm shocked and I'm going to explain why. And what would be my line of argumentation. When we have always a problem, and this was the big discussion in Portugal, all across, Isilda knows this very well, all across these last years, these last decades, is to have a woman that made an abortion imprisoned is shocking for a lot of people. And so to have it as a crime is something that is shocking. And so we always have this I'd say, difficulty to say we are totally against abortion, but then we also wouldn't like that girl or that woman that in very difficult circumstances decided to do that, then she should go to prison. This is, so this was always, what do I think that we should argue? When you look at this, I'd say even human drama, to say this is wrong, but this person probably the best way to bring this person to the good way is not necessarily to have a crime or prison. My view on this, on the issue of fundamental or constitutional right or liberty, is abortion is not really, safe and legal abortion is not a right, is a way of solving a conflict of rights. There is the right to life of the non-born, so of the baby, of the person that is there. And then you have the right of privacy or self-determination or freedom of the woman. And the legal order try to reconcile this conflict of fundamental rights and says, if you do this in the first 12 weeks or with some concrete reasons, you can do it. After this, you cannot do it. That means that for the legal order, right to life is still very important, even when abortion is allowed. Because after some months or out of some conditions, it still is something that is forbidden. So this is a solution to try to have a balance between two fundamental rights. The right to life, that a lot of us would think that is okay, it should be absolute, but okay, for a lot of people it is not. Then you have the right to life, and you have this right of privacy or self-determination, of freedom, whatever you want to call it, that every person, every human being has naturally. And they say these two rights are in conflict, and the way to solve this conflict is to have this decision. During the first 12, 14, 16 weeks, you can do this, or in case that there is a rape or something, you can do this, but after this you cannot. So we are protecting in a certain way the right of privacy or self-determination, and we are protecting after that the right to life. And if abortion is to have a safe and legal abortion under certain conditions or within some weeks or months, is a way of solving a conflict of rights, it cannot be a fundamental right. It is the legal solution to solve a conflict of fundamental rights. And I think that should be our line of argumentation. So I'm not now speaking, of course, everybody is free to say we want to say no more abortion, no more legal abortion. This is totally acceptable, as Tony has said, is a matter of conviction, personal conviction. As is also acceptable, we have to say that someone thinks that, even if they don't like very much that, they would totally accept abortion under certain conditions. These two positions, with your freedom of thought and conscience, are acceptable. What we cannot say is that there is a fundamental right to abortion. We should say abortion, to have legal and safe abortion, is a solution of a conflict of fundamental rights. And so by definition, it is not a fundamental right, because it's harmonizing rights that are in conflict. So it cannot be an autonomous right. It is the solution that the legislator has found in order to try to balance two fundamental rights. I'm saying this in this manner because I think this is the only way to avoid something that otherwise, and now I'm answering your first question, will happen. And I think that will be, in my opinion, very, very regrettable, because even for constitutional theory, this would be something that is not logical, has no sense, is totally against, I'd say, the legal and constitutional concepts. Because, as I say, when we are allowing abortion under certain conditions, we are solving a conflict of rights. We are not enshrining a new fundamental right. And so I think that this would be probably, at least is my argumentation in our committees and in our meetings, trying to avoid this. But people, they are not aware of what is a constitutional right. And they see this as everything should be a constitutional right. and that is not really, here we have to do some pedagogy. That's why I was saying that whatever is our view, our personal conviction on this matter, we should always try to bring this objective argument to the discussion. Because if we start to use as an argument, I'd say, only our convictions, even if very passionate and very well presented, at the end, this won't help. Even for the courts, I think that we should use this legal reasoning. This would be my advice, I'd say, because it is really a danger today that this step will be taken, because I see such an enthusiasm. Sometimes this is shocking, because I understand, as I said, that someone says, no, it's better to have safe and legal abortion because this saves lives, because we don't want to imprison women and so on. I understand that. I don't understand that then there is a fundamental right to abortion. This I cannot understand. It's a totally different thing. One thing is to have, and what I see sometimes is that there is even some enthusiasm, what is very sad, because if you are speaking about abortion, even if you think that it should be legal and safe, it's always something that is not a good thing. It's always made under a huge conscience debate, internal debate. It's a very difficult thing. And when we see that activists speak about this with joy and as a great victory, as a battle, this is, in my view, also something that we should really condemn. That I would condemn. I would say, no, I understand that you fight for this if you think this is right, but not as if this was something very good. Is, as I say, a way of solving a conflict, is not a way of implementing a right, because that right doesn't exist as such. Again, in a certain way, is coming, and with this I would conclude, to our initial remarks that if we look at human issues, at social issues, and so on, we'll see that we can approach this matter with compassion and with some tolerance, even we can do it, but that doesn't mean that we should acknowledge a fundamental right. So even for the ones, so I'm not saying, I'm saying for even for me, what is shocking is that the people that defend safe and legal abortion, and they think that this is the best solution, even them, they should not claim for a fundamental right. That is, and here we should do this pedagogy to show that this, because as I said, I don't say anybody should give up from their convictions and from their fight and from their, of course not, but being very realistic, we should concentrate our efforts now in this matter, trying to avoid this step, because this is a wrong step. By the way, only one comment on Tonio Borg, only to say that in federalism theory, it is true that family law and criminal law, with very few exceptions in the case of criminal law, are state level and not federation level. So even in a true federation, family law and criminal law are always a competence of the states, not of the federation. And so if we are not a true federation, we are this, ambiguous federation, I'd say, it would be very strange that we would have a solution that is even more centralized, I'd say, than in a normal federal state. So it's only to say that I fully acknowledge your view on this, in this case, subsidiarity argument, that is a classical for federalist theory. Is really a classical concept of federal theory.
Thank you. Thank you, Paulo.
Well,
Thank you, Paulo. And thank you, four of you. I was asked to be your moderator. I've been completely useless as a moderator because you have behaved very well and even on the time schedule. So thank you so much. Just let me make a final argument after your interventions. When the French presidency said, we have to move forward and get abortion as a right of the European Union, I'm a devoted pro-European. I think this is anti-European because it's exactly the opposite of what he believed was saying. I do believe that if abortion would have a legal base to rule on at European level, it would harm the Europeans because, as you all said, this has to do with national legislation and not with European legislation. So the pro-Europeans, the devoted pro-Europeans, all of you are here, should be against, especially because of European reasons, because it will harm the European Union if we start bringing up to Europe what should be solved at national level. So the useless moderator says, thank you very much for you. I prefer to be your role model. I'm going to immediately back to Spain to tell them I'm your role model. And the third panel should take our place. Thank you very much. Thank you.